This is WPSL Port St. Lucie, the talk of the Treasure Coast.
You're listening to WSTU Stuart. The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. This is Stuart Address, and this is Ask a Lawyer. It's August 13th, 2021, Friday the 13th. I'm not going to look for any black cats.
I was going to bring one over to the house.
Thank you. We do not accept donations of kittens anymore. No more animals in this house. I've outgrown them. Oh, goodness gracious. And we have so much else to talk about other than kitties. Why don't we finish a little story I was talking about last week regarding this Family Medical Leave Act trial. We were almost through with it. For those who may not have really heard the show, I'll give you a real quick summary. Number of years back, I represented a client who worked at a local bank, and she needed time off because her daughter threatened one morning to jump off the bridge in Fort Pierce with an infant. And she had problems getting that leave at the bank, finally got the leave. And then when she came back, she was given a different job and all of a sudden began getting write-ups, and that led to a fairly quick termination. So we filed a lawsuit under the Family and Medical Leave Act. And we spoke last week about discovery and some of the fun things I found out about Farmville and playing games on the bank's computers during work hours, and how this actually helps impeach a witness and impeach their credibility. And we sort of left off as the trial started, and I had questioned some of the bank officials. They had given me a hard time. They had so frustrated the jury that a couple members of the jury who were very close to counsel table, and that was a very small courtroom, we were able to hear saying, just answer the question, just answer the question. And we know we were scoring some points. We put my client on the stand, and she manages to get through direct examination. I had practiced with her. Has trouble on cross-examination because whenever the infant, the baby is mentioned, she breaks down in tears because of what almost happened. And ultimately, she runs out of the courtroom once and then a second time. And second time, the judge gives a warning. Mr. Address, if your client can't finish cross-examination, I'm going to have to declare a mistrial. And I go out and I find that my client is locked in the ladies' room of the federal courthouse. Her husband, who has been separated from her because he's going to be a witness, wants to go into the ladies' room to console her. And of course, this creates a commotion. And I go back into the courtroom and ask the judge for permission that a witness get to speak with another witness. But since it's the husband, that he be allowed to speak to her just for the limited purpose of calming her down. I mentioned to the judge that she sort of locked herself into the ladies' room, and we need to let him go into the ladies' room. And so the arrangement is that with a U.S. Marshal, the U.S. Marshal and the husband will go into the ladies' room and talk to the wife and get her back into the courtroom.
And they have female U.S. Marshals too.
Yes, there was a female U.S. Marshal. And I got to tell you something. The U.S. Marshals in all the trials I've ever had in federal court, the U.S. Marshals have been wonderful. Polite, interested, in some cases, very attached to the video monitor because it's they think it's a fascinating trial. I've had some U.S. Marshals ask me about, well, who's going to be testifying tomorrow? It becomes a soap opera. But here, yes, a female U.S. Marshal was allowed into the ladies' room. We got my client back to the witness stand. She managed to complete cross-examination. Thank goodness we survived. And we are winding down. And I have the bank's senior vice president and director of human resources on the witness stand. And I'm speaking to him about some write-ups that had recently been issued to my client, but we'll talk more about that after we take a caller on line 1. Hello, can I help you?
Go ahead.
Yes. Good morning, my favorite lawyer.
How you doing?
I'm all right. I'm hanging in there. Without going into too much detail, I want to ask you a question.
Sure.
I've been recently asked to be a guardian for a fellow that's having some difficulties. And I didn't know what it entails and what, I don't mean to say my power, but what authority do I have?
Well, it depends upon whether the guardianship is being issued by the court or whether you are all having legal papers drawn up that will describe the extent of your rights. It could be very broad. It could be the right to take control of assets, sell assets to cover expenses or care. It could be the right to make decisions regarding medical care. It could go to the right to, quote unquote, pull the plug. Or a guardianship can be fairly narrow. Depends upon how the legal papers are drawn or the court order is issued.
Okay. I think that I think what they were, what they wanted from me was to make decisions in medical care. I don't know if the court ordered it or if they took it on themselves, you know,
Usually that is done on your own. I mean, you don't usually go to a court to get an order unless it's really serious for medical care. There are, you know, you can call it a guardian. Go on.
They petitioned the judge to keep him, you know, under supervision and care for another 30 days or so. And that's when they asked me if I would be the guardian.
All right, then what you need to, you need the order appointing you the guardian so that you can see the extent of the powers. If it is limited to rendering decisions on medical care, that would be the extent of your powers. You know, perhaps he has no other family, you know, that's local or living, and you as a close friend may be the one that, you know, he preferred or somebody determined would be best suited to act in his best interests. And that's really all the guardian is you're supposed to act in the best interests of the person whom, you know, you have care for. You know, unlike the conservatorship for, was it Britney Spears?
Yeah, he could get some advice from Britney Spears' dad.
Yeah, it's not quite a conservatorship, but it can come close at times if it's a very, very broad guardianship.
Okay.
So I would get the order itself because that's going to lay out the parameters of what you legally have authority to do or be included in.
Okay, that sounds good.
All right. Thanks for giving us a call again. Take care.
When I hang up, will you tell Greg what you think of DeSantis?
Oh, we're going to get into that in the show. Absolutely.
All right, thank you.
We're going to get there very quickly. Take care. Bye-bye.
Well, yeah, guardian. Now, what he would have to go back to the court to get, what is it, a medical power of attorney?
Right. There's a durable power of attorney, or, you know, a lot of people sign what are called the 5 wishes, and that lays out what kind of medical care you want, who you want to make the decision. There are a number of names that a document like that can have. They're fairly common these days, and very often you can literally pull one up on the internet, just get one that's sort of approved by, Florida Department of whatever. They're pretty easy to do yourself. And for the most part, they're designed to do yourself. This was a situation where there was actually a petition, obviously, to keep somebody under care for an additional period of time. And so that decision was being made for the person. And there was an order, providing some extent to rights for our caller to make those decisions. All right. So, again, 340-1590, folks, 772-34.
Uh-oh. And Stuart
Feel
address.
free to call,
Oh,
ask a
there you
question or comment.
Yeah, you were frozen at your end there.
I was?
Yeah. Yeah, right in the middle of the phone number, 340-1590. There you go.
Yeah, feel free to call. Anyway, so we are examining this senior vice president, and I've made a lot of headway, but I haven't sort of had the smoking gun. Well, there was a smoking gun. I just, in the mass of thousands and thousands of pages of documents, had not personally looked at it. Fortunately, I had a paralegal who was aware of it, and as she's nudging me while I'm examining this witness, I'm pushing her away because I'm laser focused on the examination. She tries to shove a note in my face, which usually works, but not here, where I was really trying to focus in on this guy and not let him off the hook. And finally, she had a little bit of chutzpah, and sometimes that's necessary, folks. Don't ever surround yourself with yes people. Yes people get you into trouble. You need somebody who will take some risks. And here she stood up, she walked up to the lectern, she put this document in front of my face, and she whispered, "Read it." Well, I asked the judge for a moment, and I read it. And it was a policy that was rather important. And so I go to the witness and I said, you've written the plaintiff up, as a teller for being over or under her drawer 5 times in the last 30 days. Is that right? Yep, that's right. And these overages, these underages, they range from, I don't know, $2.50, $3.27, $5.21. Well, forget the $5. Let's say $4.21 for the purposes of this point. Yeah. Well, wait a second. Now, you're the human resources director also, aren't you? Yeah. And in fact, you developed the policy manual for the bank. Is that right? Yep, that's right. So you're familiar with all the human resource policies. Yeah. You're familiar with all the teller policies. Yeah. Isn't it true that your own policy says that tellers should not be written up for any overage or underage less than $5? Well, let me show it to you. Your Honor, may I approach? Give the guy a copy. Isn't it right there in your own policy not to write up under $5? Yeah. So in other words, the plaintiff should not have been written up for any of these things. Well, you see, I don't need him to admit it at that point. It's eminently clear. It's fairly good for me. That's why on TV you will see, sometimes a lot of things on TV are fake. Some of them are real. Sometimes on TV you'll see a lawyer questioning a witness, and before the witness finishes an answer or even answers sometimes, the lawyer will say, I have what I need, nothing further. Because sometimes the look on the guy's face or even the is enough for you to make your argument to the jury.
That's a Perry Mason moment.
Well, that was a wonderful moment, I must admit. You don't get a heck of a lot of them, but that was a wonderful moment. And so trial ends, jury gets instructed on the law, the jury retires. And now what do? Well, you sit around the courthouse and wait and wait and wait and wait. Now, this was a Friday, and we sort of assumed that the jury would want to get out early, at least, by 5 o'clock. Now, that could mean that the trial would get continued to Monday if they hadn't reached a verdict, or maybe they were going to try to reach a verdict, by 5 o'clock. And so the hours tick by, and it's getting close to 5 o'clock, and we have no verdict. And it's 5:30, it's 6, it's 6:30. Finally, the U.S. Marshal, the courtroom marshal, comes out and says, "We have a verdict." Now, I must tell you, as a trial lawyer, those are the 4 most terrifying words in the English language. We have a verdict. Why? I mean, you're done with the case. You've done all the hard work. Why is that so terrifying? Because if you believe in angels, if you believe in fairy dust, if you believe in the power of mind, telepathic mind power to the jury, all of your influence is now over. The verdict is in. It is sealed. Okay, the judge doesn't even know it yet, but it's in. Ain't nothing you can do about it anymore. So from the time you hear the jury has a verdict and you get into the courtroom and both sides reconvene, and then the judge comes out and the judge asks if there are any other preliminary matters before the jury returns. And usually it's none, but you go through anything you need to. And all this time you're thinking, any trial, you're thinking, what's the verdict? That's the only thing you care about at that point. What's the verdict? So now the jury comes sauntering on in. You've seen this on TV a million times. And they never look at you. They just don't. They really do look down and go into the jury box. They're not looking at anybody. Nobody has to tell them that. It just seems to be human nature. And they sit down. The judge says, "Have you reached a verdict?" The 4-person, you now finally find out who the 4-person is, which tells you something. Because remember, you've picked these jurors, and so you know a little something about them. And who they picked as a 4-person tells you who was the leader in the jury room. And that may give you a hint as to this is good for you or bad for you. So the jury, the 4-person says, "Yes, we have, Your Honor," hands it to the U.S. Marshal. The Marshal hands it to the judge. Judge opens it, reads it. And then depending upon the court you're in, either the judge reads the verdict or the judge hands it to the court clerk to read the verdict. The judge, at least in Florida, does not hand it to the 4-person like on TV to read the verdict. I have never seen that done. So we find out finally that we have proven an interference with the plaintiff's rights under the Family Medical Leave Act. And more importantly, we have proved retaliation. And the jury awards a monetary amount, to which post-trial I'll make a motion for an award of attorney's fees that far exceed that amount, which is what really happens. And spend all these hours on a trial on a contingency fee basis. And I won't even get into the numbers, but I will get into the salient point that I really wanted to tell. 2 or 3 years later, we have what we call a PNC, a prospective new client. We have a PNC consultation back in the old days in the office. Oh my gosh. No gloves, no mask, no nothing. We have a consultation in the office, and I don't remember what the person was coming in about, but she comes in and we sit down in the conference room, and as usual, I ask, "How did you hear of us?" And she says, "I was a juror on the FMLA case." And my mouth had to drop. I have never had the opportunity to ask a juror what happened in the jury room. I've never gotten the insight as to how was a decision actually reached. I've never even been selected for jury, which I desperately wanted to be, so that I could at least be in that role, understanding what really goes on behind those closed doors. So I said to this woman, I said, well, that's amazing. Please do me a favor. I promise we will get to what we're here for, but you have to answer something for me. How did the jury come to the conclusion on liability that we were right, the plaintiff had been retaliated against? And how did it come to the monetary number? And I'm told that they hated the bank witnesses. They didn't believe a word out of their mouths. And that the story about the daughter and the baby and the bridge was very emotionally tagging, which we thought it would be. I said, well, okay, well, how do you come to the amount? And I hear, well, that was a compromise. What do you mean? Well, there were 5 of us who wanted to award a lot more money. And there was one who didn't want to award anything. I mean, she would go along with liability, but she really didn't want to award very much at all. And so most of our time was spent arguing with this woman over why and trying to reach some number that we could all agree upon. Now, who did this one holdout end up being? This tells you a lot about voir dire and selecting a jury. It turned out to be the only juror that worked at another bank. Now, those of you who may have been with us last week may recall my mentioning that when I was faced with this prospective juror, who was another bank official, I thought long and hard about whether to strike her with a peremptory challenge or to leave her on the jury. Was she going to help me or hurt me? Was she going to say, oh, that would never happen at our bank, and slam the competitor bank? Or was she going to take the management perspective and say, tough noogies? Well, I thought that she would probably jump at the chance to slam a competitor bank, and I was wrong. She was the one who basically wanted to minimize the award to the plaintiff, and to some extent she succeeded in doing that. And that is the only glimpse I have ever received into what really happened in a jury trial that I've been involved in.
So she almost became an artichoke.
Yeah, well, she almost became a I lost the case type juror. You know, it's sort of like 12 Angry Men. Well, this was, 6 angry people, but only one of them was really angry, and she wasn't able to bring the 5 others to her point of view.
In our first Raiders trial, where Al Davis was suing
Yes.
the National Football League, there was one artichoke on that jury. And it just so happens it went back about 15 years earlier, actually longer than that, when Al Davis was trying to get a World Football League team.
Ah, yes.
And this guy was also bidding for that team and didn't get it. Actually, and so as it turned out, and nobody, you talk about voir dire, no one on the NFL, and those guys were like the best of the best attorneys, nobody figured out who this guy really was.
And this is what happens. You can never figure out everything in a prospective juror's life. You hope you hit the right points, and then you hope you make the right decisions. But it is an art. It is not a science. And even if I had, I don't know how familiar you folks are with the old TV show, but even if I had Bull on my side giving me advice, I still don't know whether that bank official would have been on or off the jury.
That show fascinates me. Do they really exist, trial scientists?
Yes, they really exist. It is really, well, I won't say a profession. It's because it's an art. It's not a science. Any psychologist could help get into the mind of the type of juror you want the types of questions you should ask, what you're listening for, certain cues to be aware of. I mean, that could be done by, any psychologist, but to rise up to the level of being truly skilled at it in the law, understanding the law and, individual dynamics and the psychology of groups. Yes, that it's a specialty. And do they really get it right? I don't know. I've never had one. But I would have to think that they would certainly be very, very helpful in coming up with the questions that you wanted to ask the prospective jurors during voir dire. I have to believe that if I had the money to hire one of these trial scientists to help me with voir dire, that the question set that I would have would be somewhat different than the question set that I develop on my own.
Yeah, because some of the questions that are asked on that TV show are like, what colors do you like and stuff like that. And I think, how does that relate?
Well, okay, here's a standard question. Maybe you've heard it, maybe you haven't. What bumper stickers are on your car? Do you think that would be helpful?
Oh, okay. That's interesting.
How would that be helpful? How would that be helpful?
Well, if they're political bumper stickers, that would really tell you a story.
That's right. So if it says Trump 2024, that may tell you a heck of a lot about who you're putting on the jury. And maybe that might make you want them or not want them, depending upon the case and depending upon who you're representing. If the bumper sticker, they have 10 bumper stickers all about unions. Oh, that really tells you that they probably are very much in favor of employee rights. I'd love to have that person on one of my employment law claims, one of my discrimination claims. So yeah, there are odd questions that really do have a purpose. One of the standard voir dire questions these days is, have you heard about the McDonald's coffee case? Everybody has. How many of you believe that the verdict awarded the millions of dollars that was awarded the person who burned themselves, that was excessive? Almost all the hands go up. And then you say, well, let me give you some additional information. We talked about this on another show, so I'll make it really, really quick. You start giving them little pieces, and how many still believe it was excessive? And less hands are up. And then you give them the final piece of information, the piece that is never reported in the media, and the piece that's really essential to know. You say, what if we told you that McDonald's had an internal memorandum a couple of years earlier that said the temperature of these coffee machines exceeds the level that would scald a human tongue, and we should retrofit our coffee machines. Retrofitting would cost $2.72 per machine. Well, count the number of McDonald's worldwide, it probably comes to several $1 million. And McDonald's decided, the cost of lawsuits would be less than the cost of retrofitting all the coffee machines. Now you have that information. And I say, now, ladies and gentlemen, how many of you believe the verdict was excessive? You'll have only a few hands up. They're not going on my jury. If they still believe that, they're not going on my jury. But what I have shown is the others were able to be persuaded. And that tells me there's at least the potential of having a fair jury.
That's amazing. That truly is amazing. I got there news item that came through our National Association of Broadcaster bulletin yesterday afternoon. Cumulus Broadcasting, which along with iHeart, those are the two biggest, is opening their radio stations up on October 11. And all people who enter the building have to be vaccinated. And if the employees are not vaccinated, they're gone.
That's right. A lot of companies doing that have to be vaccinated.
Okay, now isn't that some sort of a violation?
No, no. Really? Look, there are court cases going on right now about that. And there are very few decisions yet. But the ones that have been made are that, no, that is not a violation. It's a private employer. A private employer is making a decision that this is a condition of employment. It is not based upon your race, your age, your gender, your national origin, your disability. It's a decision. Everybody has to be vaccinated or you no longer work here. That's like saying everybody has to sign a non-compete agreement or you can't work here anymore. Nothing wrong with that. Why is there anything wrong with a vaccination? So no, I don't think so. In fact, it may not be within the power of the president to require this, but I will tell you, other countries, other democracies, of course, don't have our constitution, but other democracies are requiring citizens to be vaccinated, including they're beginning in certain provinces in Canada and Israel. It's designed to protect against those who will not be vaccinated. Sounds familiar. And that's what we're going to talk about now. We're going to talk about schools open this week. And you have to be living under a rock if you don't know that our governor DeSantis issued an executive order, which he described as prohibiting school districts from issuing any mask mandates under threat that the school district's funds would be withheld and under threat that board members and superintendents who voted for mask mandates would have their salaries not paid. So let's talk about that. And let's talk about what some districts have done, including our local ones. And let's talk about civil disobedience and how I am shocked that so many people have had the stones to tell the governor, go shove it, under threat of serious consequences. So DeSantis has a memorandum issued to the press about his executive order that he's about to sign ceremonially in a media conference. And the memorandum is from his director of communications. And it says that the executive order was being issued, quote, in response to several Florida school boards considering or implementing mask mandates in their schools after the Biden administration issued unscientific and inconsistent recommendations that school-age children wear masks, unquote. Seems very clear about what he's about to do. In his press conference, the governor described his own executive order as prohibiting any school district from imposing any mask mandates. That sounds very definitive. And the governor said, quote, well, he threatened, quote, to take away funding from any district that infringes on the fundamental right of parents to make health and educational decisions for their children, end quote. Now, I got to admit, that's a great bumper sticker. I mean, that sounds like a great, position to take. I am going to stand up against the infringement of the parents' rights to make health decisions for their kids. That sounds really great until you look at the facts. Now, he continued, we have had a lot of push from the CDC and others to make every single person, kids and staff, have to wear masks all day. That would be a huge mistake, end quote. Well, now, it seems very clear what his executive order is, how he's describing it. It's a no masks. Now, the Florida Board of Education, in conjunction with the governor's press conference, where he signed his executive order, announced that it would provide vouchers for parents who see mask wearing requirements as harassment. And they would make such children eligible for a HOPE scholarship, which would allow the child to transfer to a private school or a public school in a different district. Now, they're taking this really seriously. They're basically saying to the school districts, don't have mask mandates or there are going to be serious consequences. But wait a second. When I talk to you about the withholding of the salary, this is what DeSantis said. If a school district were to vote in favor of mask mandates, quote, the State Board of Education could move to withhold the salary of the district superintendent or school board members as a narrowly tailored means to address the decision makers who led to the violation of law. End quote. A lot of threats, a lot of intimidation, a lot of pressure. We know that he was hoping to get a position in Trump's cabinet for the second administration. So he's modeling himself after somebody, and the threats and intimidation are pretty consistent with that. So President Biden, in speaking about Governor DeSantis and other governors who were standing in the way of local mask mandates, not just for schools, but generally, said that, quote, they should at least get out of the way of people who are trying to do the right thing, end quote. Well, DeSantis responded, now we have a pissy match. DeSantis responded, quote, if you're trying to deny kids a proper in-person education, I'm going to stand in your way, and I'm going to stand up for kids in Florida, end quote. Wait a second. Did Biden ever say he wanted to keep schools closed? I don't think so. That's a wonderful thing to say, but Biden never said anything to the contrary. DeSantis also said, quote, if you're going to try to lock people down, I am standing in your way, and I am standing for the people of Florida, end quote. Well, hold on a second. He never advocated for another lockdown. So to say that, you're going to stand in his way, well, it's just, showboating. That's a word another president liked, showboating. President Obama liked to talk about showboating. So to me, it looked like the executive order was initially presented as prohibiting mask mandates, but guess what? That's not what it said. And we're going to get to that in a moment. If you read the executive order, that is not what it says. And ultimately, DeSantis has to back down a little bit. Now, DeSantis also said about Biden, and I love this one, I just love it. He concluded his little political grandstanding with, I don't want to hear a blip about COVID from you. Sounds like somebody running for president in 2024. Now, Biden's press secretary, in response to a question at the daily press conference, indicated that President Biden was considering directing federal funds for Florida, which were part of the American Rescue Plan, to those school board employees who actually lost salary as a result of any action by the governor. Now the president's sort of trying to say, don't worry about the threats. If it happens, we'll just use money that we're already allocating to Florida, and this will be one of the ways we use it. Well, that didn't sit too well with DeSantis. But where does that leave us? There are a number of school districts, most of them, I think, that still do not have any mask mandates. These include Polk, Pasco, Pinellas, Hernando, Sarasota, Clay, Collier, Charlotte, St. John's. They're all masks are optional. So they're not prohibited, but they are optional.
They're red counties.
Right. Manatee, voluntary, only because of pressure from the governor and a vote where a new board member was appointed by the governor. Now, in that county, in Manatee, after the first 3 days of school, there's more than 100 COVID positives for students and employees. That makes a little connection there. Now, Miami-Dade surprised me. Not yet. Not yet for schools. School buses, yes, but not schools. It's under discussion. And the school superintendent said a couple days ago that the school board will not be influenced by the governor's threats. And a decision will be made soon. You should know that in Miami-Dade, while it's only for school buses, in the county, for county buildings, you have to wear masks. That has nothing to do with schools, but just sort of an aside.
And it's been that way for a long time.
And a lot of counties are like that. Brevard, no mask mandate, a 3-2 vote on August 10th. Now, to require a mask mandate in the face of the governor's executive order, in the face of how he described his executive order, in the face of the threats about loss of school funding, in the face of the threats about school board members losing their salaries or the superintendent, one would think that everybody's going to knuckle under because these are powerful threats. To my utter shock and happiness, we have so many counties who have basically said to the governor, I dare you, I double dog dare you. Go ahead, try to take away funding for the next school year. Let's see if you're really going to do it. You'll never get reelected. I triple dog dare you.
Isn't that a local decision of the local health
Well,
department?
that's what they say. That's what they say, and there are 2 lawsuits about that as well.
This kind of gets back to with some of the council forums that the League of Women Voters did on home
Yeah.
rule.
That's right, home rule, absolutely. So to me, it's sort of, if you're now a school board and you're going to vote for a mask mandate, it's an act of civil disobedience. You have been threatened. You've been subject to intimidation. If you're going to do it anyway, then that's civil disobedience, because what you're doing, according to the governor, is a violation of law. And you are going to take your risks. So who has done it so far? Well, Broward's done it. School visitors, students, faculty, all have to wear masks. Orange has done it. Same thing, students, faculty, employees. Oh, and Orange has done something else. It is now requiring more than 4,200 non-union county employees to be vaccinated. That gets to your comment, Greg. 4,200 non-union employees. Why non-union? Because if it's union, you've got to negotiate this with the union. If they're non-union, you impose your conditions of employment.
Come on.
All right, so now let's look at Palm Beach. Yes, school mask requirements for students, faculty, and visitors. All employees and visitors also to county facilities. And even with the mask mandate, the first 2 days of school, 131 confirmed cases of COVID, 26 employees, 105 students, and it's led to the quarantine of more than 400 students and employees in the first couple days of school earlier this week. Now, let me tell you one thing that is in common with all these counties so far that are standing up and saying, yes, masks are mandatory. There is an opt-out provision. And that becomes very important in a few moments. There is an opt-out provision whereby a parent can formally, in writing, opt out of the mask mandate for their student, their child, and their child doesn't have to wear a mask. But if you don't have an opt-out, then the student will be forced at school to wear a mask, whether the student likes it or not. So let's go through a few more. Duval, yes. Alachua County, yes. Hillsborough County, yes. Monroe, yes. Lee County, the district in which Governor DeSantis issued his executive order, yes. And Leon County is requesting permission to have a mask mandate. It was a little bit more nervous, I guess, and it wrote to the governor, and in its letter to the governor asked for, quote, the flexibility and the autonomy to make the decisions for our schools that best fit with our local data and information in Leon County. So far, there's been no response from the governor. Seminole County. Yep. And guess what? St. Lucie County. Now, school started on Tuesday. Tuesday night, I'm watching TV, and a news story comes on that literally made me sit still in rapt attention. The St. Lucie County School Board had just voted to require masks for all public school students. 4-1 vote. I gotta admit, I was in shock that they had the cojones and the stones to stand up to the intimidation and the pressure. I applaud them, and I've criticized them several times with this program. I applaud them. Now, what does DeSantis do in the face of all these counties who are disregarding His Holiness's mandate? Well, he backs down a little bit, makes it as if that he's doing something wonderful for them. And he says that through a spokesperson, acknowledges that, well, in terms of the pay of the superintendent and school board members, he has no authority over that. So the threat was empty. Why does he have no authority? They're not state employees. How could he have authority over what they're paid? All right, so we have the threat, we have the intimidation. It hasn't worked a lot. What does the executive order really say? I'm going to tell you. I'll tell you very briefly the first 3 sections, which are the key ones. Section 1 orders the Florida Department of Health and the Florida Department of Education to execute rules, quote, to ensure safety protocols for controlling the spread of COVID-19 in schools that do not violate Floridians' constitutional freedoms and does not violate parents' rights under Florida law to make healthcare decisions for their minor children, end quote. Okay, well, I don't see anything wrong with that. I mean,
Local health departments already do it.
that's what it sounds like. Section 2. They're required to, quote, protect parents' rights to make decisions regarding the masking of their children in relation to COVID-19, end quote. All right, I may not completely agree with that, but I certainly do understand it. So parents' rights. Well, that means the parents make the decision, not the governor. Section 3 gives the authority for the state to pursue all legal means available to ensure school districts adhere to Florida law, including but not limited to withholding state funds from non-compliant school boards violating any rules or agency action. Okay, that's a nice threat, but what's it a threat about? Nowhere in the executive order, nowhere does it say mask mandates are prohibited. Nowhere does it say what the governor said he was signing. Nowhere does it say the way he described what he was signing, what his director of communications described, what the State Department of Health described. It doesn't say it. What it says, essentially, is as long as there's an opt-out so that parents are maintaining the right to control masking for their children and making the quote-unquote healthcare decisions for their children, that mask mandates are fine. And so either realizing that or not, I tend to think they probably had some lawyers study the executive order very carefully and sort of said to themselves, it doesn't say this. So we're gonna vote for a mask mandate. We're gonna give parents an opt-out, and therefore we're in compliance with law, notwithstanding what the governor says it says. So really, I think these numerous school boards who voted for these mask mandates, even with the opt-outs, demonstrated strength and courage in the face of imposing threats and intimidation, which included the governor actually misstating, intentionally, willfully misstating the content of the order he signed. Because how many people are really going to read it? How many parents are going to read the executive order? How many lawyers are going to read the executive order? I got curious. I read the executive order.
Well, wasn't he realistically speaking to the other 49 states? And
DeSantis?
voters in the other 49 states?
Oh, yeah, well, he's running, so sure. He has to show himself to the, I'm being cynical here, but I know I'm right. He has to show himself to the Republican base as being a quote unquote true conservative, though it's not what conservative has ever been defined as in the Republican Party before.
And of course, if those fines wind up in his campaign account,
Yeah,
everybody's happy.
it's certainly not a McCain conservative. And one final point on this, there are now 2 lawsuits that have been filed against the governor over the executive order, because the argument is they violate Florida Constitution's right for a safe public education. Article 9, Section 1 says that the education of children is a fundamental value of the people of the state of Florida, and it is of paramount duty to make adequate provision for the education of all children, which is safe and secure. So that's a Floridian constitutional right. And I would argue that requiring my child to go to school and prohibiting a mask is not guaranteeing him a safe and secure education. And that's the essence of both lawsuits that are pending right now against the governor. So I know we're just about out of time. I don't know about you, I've had some fun. I love it when people stand up to power. And so I will be back next Friday on a non-Friday the 13th for another edition of Ask a Lawyer. Be safe, be careful this weekend, next week. Get vaccinated and be wary of any open ladders and black cats. Take care. Have a good day.
You've been listening to Ask a Lawyer, the Friday the 13th edition, right here on WPSL Port St. Lucie and WSTU Stuart.
Yeah, an extra 20 seconds.